Hello, thank you for joining our channel. We're still on our agency series, and today we'll be taking remedies for breach. That is, remedies that are available for a principal or an agent where either of them has breached their terms of contract. And I'm sure you already know that a remedy is a legal solution that is available to someone who has suffered some type of damage or the other from another party. So the breach of an agency relationship may give rise to a claim for damages for any of the other parties or any other remedy to the innocent party, which innocent party may be the principal or the agent. But the kind of remedy that will be available to a party generally depends on which party is suffering from a breach that has occurred. It may also depend on the terms of the agency relationship. It will equally depend on the nature of the breach in issue, and finally it will depend on the circumstance of the particular case. So these four issues generally will determine what type of remedy will remedy the breach that has been occasioned against an innocent party in an agency relationship, whether that party is a principal or the agent. Now, we'll first look at this by separating the remedies available to a principal from the remedies that are available to an agent. And then we'll begin by looking at the remedies that are available to a principal in the occasion of a breach by his agent. These remedies are basically 6. They are 1. Dismissal, 2. Rescission and damages, 3. Action for account, 4. Action in tort, 5. Private prosecution, and finally withholding of commission or remuneration and an action to recover same. So you can withhold the commission or remuneration where same has not been paid to the agent, but where same has already been paid, you will in the alternative cause an action to recover either the commission or the remuneration as the case may be. So we'll begin by taking a look at what dismissal means. So the principal may bring the agency relationship to an end or otherwise dismiss the agent from his employment without notice due to a breach of the agency agreement. In an action of this nature, for wrongful dismissal or for indemnity, the principal may set up the agent's breach as a complete defense or as a complete defense to the action generally. Then the next thing we'll be looking at now is rescission and damages. The principal may rescind any contract entered on his behalf by the agent without his authority. Now, in addition to rescinding or withdrawing from that contract, the agent may also be accountable to the principal for any damage resulting from that breach, and he may be required to refund any secret commission he got in the course of entering such a contract, or profit he made, or any other advantage he obtained from such a contract that he entered without the authorization of his principal. And authority is given as the case of Armstrong versus Johnson. You will see the citation supplied on the screen. Thank you. We will also examine action for account. Action for account. Action for account is a remedy that requires the principal to go to court, that is to take an action in court against an agent, demanding or praying the court to compel the agent to tender accounts or render accounts or give him accounts of his agency while it subsisted. So the principal may take an account to compel the agent to render an account of all his dealings on the behalf of the principal in respect of their agency relationship. The agent may also be made to account for any money, any property had or received on behalf of the principal in the process of executing the terms of such an agency. An authority is given as the case of Godwin versus CAC. The citation will also be supplied. Action in tort. The principal may, in addition to any other remedy, also sue the agent for conversion where that agent had received property on his behalf and had misappropriated or misused such a property. The principal may also institute an action in negligence based on the negligent performance or discharge of such an agent in the course of his duties, provided the agency relationship is not contractual in nature. So in respect of conversion, you can see generally such authorities as Iheanacho versus Uzochukwu, and in relation to negligence particularly, you can see Odinaka versus Mohal, and the citations are also supplied. We now move on to the remedy of private prosecution. The remedy of private prosecution. The principal is entitled to take out a direct criminal summons against the agent where that agent's conduct, his act or omission amounted to a crime in its very nature. So this will be in addition to any other remedy that the principal had earlier sought for himself. Finally, we will be looking at withholding of commission or remuneration, or in the alternative, an action to recover same. The principal, by way of a remedy, may decide to withhold his commission or the commission of the agent or the remuneration of the agent. So if the agent had made him to suffer some form of loss, assuming the agent entered into a transaction he didn't authorize him to, and he suffered some form of loss, he may decide to use the commission, the normal commission of that agent, to pay himself back for the damage he has suffered by way of the agent going into a contract or transaction he has no authorization so to do. And by so doing, he would have remedied his the loss that he has suffered. It would be like a kind of restitution ad integrum, restoring him back to the place where he was before the agent entered into that transaction and made him to suffer such consequences. But where he has already paid the agent's commission, there will be no commission to hold on to by way of restitution ad integrum. He can, therefore, in lieu of this, go to court seeking the court an order to compel the agent to return to him the commission or the remuneration that was paid in error. So in this regard, therefore, it will be said that he took out an action to recover either commission or remuneration. In other words, the principal may refuse to pay the agent his commission or remuneration in connection with the transaction, or to sue for the recovery of any commission already paid to the agent. In the case of Andrews versus Ramsey and Company, you see the authority supplied. A instructed R to sell a property and agreed to pay him £50 commission. R sold and received £100 from the purchaser as deposit, of which he paid £50 to A, retaining the other £50 in payment of his commission with A's consent. A learned that R had also received £20 as commission from the purchaser and sued to recover the £20 and also the £50 he had paid to R. It was held that he was entitled to recover both sums from R. Thank you very much. We will now go to the remedies that are available to the agent in the event of a breach by the principal. The agent is basically entitled to the following remedies. is entitled to 1. An action in damages, 2. Right of set-off, 3. Right of a lien, 4. Right of stoppage in transitu, and finally, other remedies that I just classified as other remedies lumped together in that class called other remedies. And we will begin by taking a look at damages. The agent may sue the principal to recover any loss or injury he may have suffered as a result of the principal's failure to perform any of his duties under the agency relationship. Let me pause here and say that damages are what they are. Damages are usually awarded by the court for a damage you suffered. So the court cannot award damages where there was no damage suffered by an individual. So anytime you hear that a person is taking out an action for damages, it presupposes that he has suffered a certain quantum of damage from another person's action or inaction. So where the principal has done something for which the agent has suffered some form of damage, he is entitled to an action for damages in order to restore him to the position he was before he suffered the said damage. The agent may also sue the principal and claim damages for the principal's failure to pay him any agreed remuneration or commission. You will see that where a principal fails or refuses or neglects to pay an agent a commission, he may suffer one form of damage or the other. It may be that he's not able to meet up certain expectations in another quarter, which expectation he would have used that commission to meet, and therefore he suffers something. That something he suffered is what we call a damage. And what we cure that damage he has suffered is what the law provides in the form of damages. And you'll find the authority of an agent being entitled to action for damages by way of remedy in the case of Luther versus Mandela's authority or citation supplied. We now go to the second remedy he has, and that remedy is a right of set-off. In an action of the principal against the agent may claim a right of set-off or a counter-claim of any amount due to him from the principal by way of remuneration, indemnity, or reimbursement. This must be specifically pleaded by the agent in his defense on the claim by the principal. Now, a right of set-off is best explained loosely this way. The principal is claiming something from the agent, assuming the principal has instituted an action against the agent and the principal is claiming a certain sum from the agent, say in damages. He's claim to say 50,000 naira for damages. Meanwhile, he's owing the agent 100,000 in remuneration or commission. The agent can ask for a set-off. In other words, he's requesting the court to take out the 50,000 naira out of the commission or the remuneration yet unpaid to him by the principal, which means that the agent will not be looking for a fresh amount of money or fresh sum to pay off his principal. The principal will just take the money out of the money he's already owing the agent and simply pay the agent the difference. That's what is meant by a set-off. Now, 3 now is the right of a lien. The right of a lien is very similar to set-off. It's very similar to the concept of set-off in that both they both involve entitlements that the agent is using to sort himself out. That's the only extent to which they may appear similar. But a right of a lien is this: the agent has in his custody something that belongs to the principal in the course of their agency relationship, and now he has an issue with the principal, maybe an issue that is requiring some form of payment that the principal has failed to do. The agent can hold on to that property of the principal in his custody, and he holds on to that principal's property as a lien. That's what's meant by a right of a lien. So the agent has a right of a lien on the property or goods or charters of his principal in his lawful possession or custody. Not that maybe he saw the principal's property somewhere and he now went and hijacked it. No, it's the property that is already in his custody lawfully. This is different from, say, seizing, going to go and steal the principal's property and claim that it's a lien. That property has been in his custody before now lawfully. So he now holds on to it. He now holds on to it as a form of claim for his remuneration or the losses or the liabilities or the expenses he has lawfully incurred and for advances made in favor of his principal. This right is subject to any agreement between the principal and the agent. So if in their agreement now they had already excluded that he should not take such a property for a lien, he may not have the power so to do. Basically, there are two types of lien that are recognized in law. These are the general lien and the particular lien. The general lien enables the agent to retain his principal's property, charters or goods until any sum due him is paid by his principal. A particular lien, on the other hand, only enables an agent to retain such property, charters or goods pending payment of any sum due in respect of that property, that charter or those goods. We will now move on to the fourth remedy, which is the right of stoppage in transitu. The right of stoppage in transitu. Stoppage is an English word that you already know, that is to stop something. The in transitu is not particularly an English word, but it means in transit. So when an agent stands towards his principal in the position of any unpaid seller of goods, he may exercise the right of stoppage in transitu against those goods of his principal. What is meant by this? The agent is standing in the position of an unpaid seller of goods to his principal. This principal has not paid for these goods, and those goods are in transit. The principal is not yet in receipt of these goods. The goods are still in transit. That's the operative words. When the principal has already taken delivery of the goods can no longer be said to be in transit, and therefore the agent will not be able to exercise the right of stoppage in transitu because the goods have ceased to be in transit. But when the goods are in transit, he can exercise this right by stopping the goods from proceeding to meet the principal where the principal will now take delivery of them. By so doing, he may save himself of the trouble of having the principal take delivery of the goods, and then maybe the principal will not pay him in turn and all the other things that may ensue. The agent stands in a good position when, having bought goods for his principal, he pays the seller with his own money or incurs a personal liability to the seller of the price, and then is not seeing any green light from the principal as to the payment or indemnifying him of what he has already suffered for the principal to get those goods. He may stop those goods in transit so that they do not get to the principal and then return them and get his money back from the actual seller of the goods. We now go to number 5, which is other remedies. An agent may demand an account by the principal where there is reciprocal indebtedness by two of the parties, that is by him and the principal. If he is both indebted and the principal is also indebted, he can demand for an account by the principal. He will also be entitled to withhold further performance of the terms of the agency where there has been a continuing breach on the side of his principal. Also, where the agent, in the course of executing the terms of his agency, becomes possessed of property, goods, or chattels, or even money, to which conflicting claims have now been made by his principal and a third party, he may claim relief by way of interpleader summons. When he has, however, delivered the same in accordance with the decision of a competent court, he incurs no personal liability to his principal. Thank you so much. We have come to the end of our lessons on remedies available to parties, the agent or the principal in the event of a breach. Thank you. We hope you enjoyed it as much as we did in bringing it to you. We'd like to get your feedback. So you can comment in the comment section so we get a feedback from you. If you really enjoyed it, you can give us a like. And then you want to get more videos from us, you can click on the subscription button. So till next time on this station, I remain Nwese. Thank you very much.